she walked into the courtroom unnoticed. No entourage, no theatrics, just silent determination in her eyes. The judge barely looked up. To him, she was just another nervous litigant, soft-spoken, unsure, forgettable. But by the time the gavel fell, he would never forget her name. It was a Monday morning when Evelyn Clark stepped into Courtroom 6B. The marble halls of the Monroe County Courthouse echoed with footsteps, murmurs, and the occasional thud of a closing file. Lawyers in tailored suits hurried by, their leather briefcases clutched like shields. Clerks moved swiftly, already worn by the week that had just begun. Evelyn stood out, but not because she tried to. Her coat was old, beige, and a little loose around the shoulders. She held a file folder, not a briefcase. Her dark hair was pulled back in a low bun. No makeup, no jewelry, no flair. She didn't carry herself like someone about to face one of the most feared judges in the state. Judge Marcus Halford's reputation preceded him. Arrogant, imperious, and deeply connected to the local elite, he wielded his gavel like a weapon. Defense attorneys whispered about his favoritism. Plaintiffs often walked out with their cases gutted. And when the plaintiff appeared unrepresented, as Evelyn was that morning, Halford's disdain sharpened into open contempt. As Evelyn approached the bench, the clerk called out, "Clark versus Northford Pharmaceuticals, civil matter." She responded with a soft, "Present, Your Honor." Her voice was clear, but subdued, almost too quiet for the back row to hear. Halford barely looked up from his papers. "And you're representing yourself?" "Yes, Your Honor." He leaned back, a smirk playing on his lips. "Is this your first time in a courtroom, Ms. Clark?" A few chuckles rippled through the gallery. Attorneys, interns, maybe even the court stenographer. Evelyn didn't flinch. "I've observed several proceedings," she replied. "That's not what I asked." Halford's voice had grown louder, intending to draw a reaction. "This is your first time arguing a case, correct?" "Yes, Your Honor." He clicked his pen theatrically. "Well, let's hope Northford's legal team goes easy on you. We wouldn't want this to be a teaching moment you'll regret." Laughter again. Evelyn remained still. The defense rose. A trio of lawyers in matching navy suits. One of them, Daniel Greer, was known for crushing civil litigants like Evelyn before they ever reached discovery. He smirked, too. This was going to be an easy win. Evelyn had filed the case pro se, a negligence claim against Northford for mislabeling medication that had severely harmed her younger brother. Greer was ready to bury her in motions and procedural traps. As the proceedings began, Halford interrupted her almost immediately. She attempted to reference a procedural violation. Northford hadn't disclosed certain internal memos within the discovery window. "Ms. Clark," Halford interrupted, "this isn't a blog. Cite the relevant case law, or move on." "I believe Rule 26, she began. He cut her off again. "You believe? We don't deal in beliefs here. This is a court of law, not an opinion panel. Either you're prepared or you're not." There was no mistaking the tone now. Derision masked as instruction. He was putting on a show, flexing his power for everyone to see. And Evelyn, the quiet, unassuming woman with no legal background, was supposed to play her part. Stumbling, overwhelmed, defeated. Except she didn't. She paused, looked down at her notes, then slowly turned to the exact page in the rulebook she had brought. Federal Rule of Civil Procedure 26A1, A2. "Your Honor," she said clearly. "They failed to disclose documents that fall under required initial disclosures. Specifically, electronically stored information related to internal testing results." The room fell silent. Judge Halford blinked. "And I have reason to believe," she added, "those documents contain adverse findings the company withheld from FDA reports. That would make their omission intentional and obstructive." Greer stiffened. Evelyn continued, "Furthermore, per Zimmerman versus Allied Health, 2018, suppression of discoverable materials in civil suits of this nature constitutes grounds for monetary sanctions or even evidentiary penalties. Judge Halford's eyes narrowed. He didn't respond immediately. He was recalculating. The same courtroom that had chuckled at Evelyn only moments ago now sat in silence. Her voice hadn't changed. It was still calm, still soft, but every word landed with weight. She had come prepared, not to rant, not to rage, but to cut through the noise with precision. Halford adjusted in his seat. Noted, motion to compel discovery is under consideration. He looked at the defense. Mr. Greer, I'll need a written explanation for this omission within 48 hours. Greer nodded stiffly. Evelyn said nothing else. She sat back down, expression unreadable. But if anyone had been paying close attention, they would have seen something flicker across her face. Something faint, but unmistakable. It wasn't satisfaction. It was readiness. The next court session drew more attention. Not from the media, at least not yet, but from lawyers who had witnessed Evelyn Clark's quiet command of federal procedure. Whispers passed through the courthouse halls. Some dismissed her as lucky. Others, more observant, began to wonder if the woman no one had noticed before might actually be dangerous, especially to those who underestimated her. Judge Halford, meanwhile, was stewing. He hated being corrected in open court, especially by someone who hadn't even passed the bar. His courtroom was his theater, and he the main act. Evelyn had not just defied him. She'd done it with calm accuracy. The sting hadn't faded, and so he entered the next hearing with a chip on his shoulder and a target on her back. From the moment the proceedings began, the judge's demeanor was colder. "Ms. Clark," he said, barely glancing up, "I hope you've brushed up on courtroom etiquette. Last time, you were riding on beginner's luck." She didn't respond to the provocation. She simply rose calmly and opened her file. "Your Honor," she began, "I would like to enter into the record 3 internal communications recently produced by the defendant following the court's discovery order. These emails demonstrate that Northford Pharmaceuticals was aware of adverse reactions to the batch of medication my brother received, over a month before they issued any warnings." The courtroom stiffened. Judge Halford raised a skeptical brow. "And how did you obtain these?" "They were included in the supplemental production by the defense," she replied. "Per your order." Daniel Greer, the lead defense attorney, shot her a glare. He hadn't expected her to find those particular emails buried among hundreds of irrelevant documents. He had assumed she wouldn't know where to look, or how to interpret them. But Evelyn wasn't just guessing. She had spent weeks preparing, working late into the night in her small apartment, poring over litigation manuals, civil procedure guides, and hundreds of pages of case law. She had no formal legal training, but she had something rarer: uncompromising discipline and a brilliant mind for patterns. She treated the law the same way a scientist treats data, meticulously, analytically, without ego. When Judge Halford tried to redirect the conversation, Evelyn subtly brought it back, again and again, to the core issue: Northford's internal negligence and their deliberate attempt to hide it. She quoted case law not from legal pads, but from memory. Her delivery was never theatrical, but that only made it more unnerving. It was like being cut by glass. No sound, no warning, just damage. At one point, she responded to Greer's objection regarding evidentiary admissibility. "Your Honor, under Federal Rule of Evidence 8036, business records maintained in the regular course of business are admissible as an exception to the hearsay rule. The emails meet that requirement." Halford leaned back in his chair slowly. Evelyn had just cornered them. Again. And not with emotion or appeals to sympathy, but with precise, unshakable legal grounding. Greer looked visibly uncomfortable. Even Halford had to consider the optics. To rule against her now, especially with that precedent clearly established, would risk an appeal, and scrutiny he did not want. But the real shift happened during cross-examination. Evelyn requested, and was surprisingly granted, the opportunity to question a Northford executive, an action most unrepresented plaintiffs wouldn't even attempt. The judge granted it with a patronizing chuckle. "I'll allow it," Halford said. "Let's see what the Google law degree can do." She didn't react. When the executive took the stand, Evelyn didn't badger or grandstand. She asked calm, direct questions. She presented emails one by one, building a timeline of corporate knowledge and inaction. With every page turned, her tone remained steady. The picture became clearer. Northford had known the medication batch was contaminated. They delayed pulling it because of stockholder implications. Her brother had been one of dozens injured because of that delay. The executive stumbled. Evelyn didn't flinch. She merely asked, "Did you sign off on this delay memo dated 3 weeks before the recall?" "Yes, but..." "Is that your signature?" "Yes." "Did you inform the FDA?" "No." Silence. Then murmurs. Halford looked at her now with something approaching caution. He couldn't mock her anymore. He couldn't outmaneuver her with snide remarks or procedural tricks, not without exposing his own bias. She had backed the system into a corner using its own language. And that's when the fear set in, not just in Halford, but in every person who had assumed she was weak because she was quiet. They hadn't realized her silence wasn't uncertainty. It was control. Each hearing after that saw more people arriving early to find seats. Some came just to see her. The defense began submitting motions more carefully. Even Halford interrupted less. The shift wasn't loud or visible. It was unspoken, unnerving, and absolute. Evelyn Clark, the woman no one had taken seriously, had revealed herself as a force to be reckoned with. Not because she shouted, but because she never had to. The courthouse air changed. Where once Evelyn Clark was dismissed as a misfit with no chance, she had now become the silent pulse of every proceeding she entered. Lawyers who once whispered jokes now watched her with guarded respect. Even Judge Halford, long considered untouchable, began showing signs of unease. His usual courtroom swagger was intact on the surface, but those who knew him could see the cracks. Evelyn had struck at something he'd never expected: his control. It started with paperwork. Boring, procedural, easy to overlook. But Evelyn had filed a formal motion to unseal past court rulings tied to Northford Pharmaceuticals. She wanted to compare judicial language and outcomes from similar cases, all overseen by Judge Halford. It was a curious move for someone without legal credentials. But Evelyn wasn't curious. She was strategic. And then she filed another motion. This one was to submit into evidence a string of campaign donations made to a local judicial re-election PAC. Donations from Northford Pharmaceuticals, a PAC chaired by Halford's former law partner. The courtroom turned frigid. Judge Halford immediately snapped. "Irrelevant. The court's integrity is not on trial here." Evelyn, standing alone at her podium, calmly replied, "With respect, Your Honor, I'm not placing the court on trial. I'm establishing a pattern of potential bias that could influence rulings materially connected to this case. I have a right to an impartial judge under both federal and state law." The statement sent a low hum through the gallery. She wasn't accusing outright, but she didn't need to. She was threading the needle with precision, carefully crafting a case against the judge himself without ever stepping out of line. It was brilliant. It was dangerous. And it worked. The motion was denied, of course. Halford had no intention of recusing himself. But now he was defensive. His rulings became erratic, sometimes oddly favorable to Evelyn, as if to deflect suspicion. Other times, absurdly strict, as if to reassert dominance. But every time he flinched, Evelyn documented it. She was building a paper trail, brick by brick. Then came the day she filed the formal complaint with the Judicial Oversight Board. It was a calculated risk, one that could have turned the court against her completely. But she wasn't reckless. She attached detailed documentation. Rulings where Halford had dismissed similar pharmaceutical lawsuits with nearly identical phrasing, questionable timelines of financial disclosures, and even a signed affidavit from a former Northford employee who had once attended a private luncheon with the judge. The complaint was confidential, of course, but in the legal world, confidentiality is porous. Within days, the news had trickled through every hallway of the courthouse. Evelyn Clark had gone after Judge Marcus Halford. Officially, the judge was furious. When the next hearing began, he stormed into the courtroom 10 minutes late, a rarity for a man obsessed with order. His eyes didn't meet Evelyn's. He didn't greet the room. "Let's get this circus started," he growled. But even as he tried to assert dominance, the atmosphere had shifted beyond his control. The court reporter typed faster than usual. The bailiff looked uncomfortable. The gallery had filled up again. This time, with unfamiliar faces who sat very still and took notes. Observers. Oversight. Halford tried to punish Evelyn with a denial of her latest evidentiary motion. An expert report showing the specific toxicity level in the contaminated drug batch. But when she appealed on the spot with precedent from Martinez versus Biogenics, citing the same toxicology testing methods deemed admissible in a 2021 ruling, Halford froze. He glanced at the defense, waiting for Greer to object. Greer stayed seated. Everyone was watching. Any unjust ruling now would no longer go unnoticed. With visible reluctance, Halford granted her motion. For the first time, he did so without commentary. That's when the courtroom realized Judge Marcus Halford had stopped performing. He wasn't mocking Evelyn. He wasn't flexing anymore. He was reacting, responding, scrambling, because Evelyn had done the unthinkable. Not through theatrics or intimidation, but through logic, law, and relentless precision. She hadn't just shaken Halford's courtroom. She had shaken the illusion of power that propped it up. The defense began to sweat. They had relied on two weapons: their deep bench of legal resources and the judge's friendly leanings. But Evelyn had neutralized both. And unlike them, she didn't seem to care about optics or reputation. She had no firm to impress, no career ladder to climb. All she had was the truth, and she wielded it like a scalpel. One afternoon, as she packed up her files, a young clerk approached her in the hallway. "Ms. Clark." "Yes." "I just wanted to say, I've never seen anyone do what you're doing. Especially not alone." Evelyn gave a small smile. "I'm not alone. I have the law." She didn't say it with arrogance. She said it with belief. And belief, it turned out, was more powerful than influence, especially when backed by undeniable brilliance. Halford watched her leave the courtroom that day, his gavel untouched, his authority shaken. He was no longer in control, and for the first time in his career, he knew it. The tension in the courtroom was nearly physical now, a living presence, pulsing in the heavy air as the trial neared its climax. By the time closing arguments arrived, Courtroom 6B was no longer just a place of legal procedure. It had become a stage, a pressure cooker, and a proving ground. News had leaked to the press. Cameras weren't allowed inside, but reporters swarmed the courthouse steps. The public wanted to know who this woman was. The quiet plaintiff with no law degree who had managed to rattle a titan of industry and a corrupt judge in a single sweep. Evelyn Clark stood alone once again at the plaintiff's podium. The room was packed. Not a single seat remained. Across from her, the defense sat stiffly. Daniel Greer no longer exuded confidence. His notes were a mess. The smugness had vanished. Judge Halford sat like a stone figure, drained of color. He had grown quieter with each hearing, The public complaint Evelyn had filed was now under formal review, and though he tried to continue the trial as if it were business as usual, everyone could sense the shift. His dominance had collapsed under the weight of scrutiny, and a woman he had tried to humiliate. Evelyn adjusted her glasses, took a single breath, and began. She didn't raise her voice. She didn't pace the courtroom. She didn't appeal to outrage. She simply spoke, measured, calm, razor-sharp. "Your Honor, ladies and gentlemen of the court," she began. "I am not here as a legal professional. I'm not trained in courtroom theatrics or case strategy. What I am is a sister, a witness, and someone who believes that justice, when stripped of power and politics, is still possible." There was no movement in the courtroom. "No amount of legal defense," she continued, "can erase the fact that Northford Pharmaceuticals released a medication with known toxic levels of impurities. My brother, Jordan Clark, was one of dozens, maybe hundreds, who suffered because of a decision made behind closed doors. A decision motivated not by medicine, but by money." She placed a photo of her brother on the evidence screen. He was smiling, young, bright-eyed, alive. The room breathed collectively, but silently. For weeks, the defense has tried to frame this case as a misunderstanding, a minor mishap. But I showed this court the internal emails, the testing results, the memos discussing stock impacts versus human consequences. She paused, then let her next words hang in the still air. They knew. Some jurors looked down. Others met her gaze unmoving. And what's worse, when I brought that knowledge into this courtroom, I wasn't met with encouragement. I was mocked, interrupted, undermined, not just by the defense, but by the very person charged with protecting fairness in these proceedings. All eyes shifted momentarily to Judge Halford. She continued, "But I didn't walk in here for applause. I walked in because someone had to. Because if I didn't stand up for my brother, then what would stop this from happening again? To someone else's sibling? Someone's child?" Her voice remained steady. No crack, no tremor. But behind it was a kind of grief so controlled, it carried more weight than any tear. "The law is not a weapon," she said, softer now. "It's a mirror, and sometimes it reflects things we'd rather not see. Neglect, greed, bias. But we can't change what we won't confront. Today, I'm asking you to confront it." She stepped back, lifted her folder, and nodded. "I rest my case." For a full 30 seconds, the courtroom didn't move. No rustle of papers, no clatter of pens. Even Halford, who had so often pounced after her statements with sarcasm or contradiction, said nothing. He sat frozen, jaw locked, knuckles white. Then came the unexpected. One juror wiped their eye. Another adjusted their collar nervously. Even a few members of the public in the gallery lowered their heads. Evelyn returned to her seat. Across the aisle, the defense hesitated. Greer rose, tried to deliver a counter-argument, but the fight was gone. His voice faltered. His words landed like bricks in water, dense and sinking. He cited company procedures. He blamed third-party testing labs. But it didn't matter. The narrative had been rewritten, and it wasn't just about Northford anymore. It was about a system that tried to silence someone who knew the law better than the people paid to enforce it. A system that bowed to power until someone brave enough, brilliant enough, stood against it with nothing but knowledge and conviction. When closing arguments ended, the judge offered no remarks. He simply said, "This court will recess pending deliberation." But everyone knew the real judgment had already begun, and it wasn't just for Northford. It was for him. The jury deliberated for just under 4 hours. For a case with thousands of pages of evidence, expert testimonies, and complex legal questions, 4 hours was barely a blink. But it was enough. When the court reconvened late that afternoon, the air was almost electric. Word had spread beyond legal circles. Students, journalists, and retired attorneys had crowded into Courtroom 6B. A hush settled the moment Evelyn Clark re-entered, her folder tucked under one arm, her calm presence sharper than ever. Judge Marcus Halford sat at the bench, pale and still. He hadn't spoken to anyone since the recess. Not his clerk. Not the bailiff. The complaint Evelyn had filed was already causing tremors inside the Judicial Oversight Board. No official response had come yet, but rumors swirled. About a quiet investigation, a sealed transcript review, even whispers of disbarment. For Halford, this verdict wasn't just about the case. It was about whether the courtroom he'd ruled like a king would ever truly be his again. The jury foreman stood, a middle-aged woman with reading glasses and a firm voice. She held the paper in her hand like it weighed more than the gavel resting beside the judge. In the matter of Clark versus Northford Pharmaceuticals, we, the jury, find in favor of the plaintiff. A gasp broke through the room. Evelyn didn't move. Her eyes remained fixed on the foreman. We award damages in the amount of $2.4 million, plus punitive damages of $6 million, on the grounds of gross negligence and willful suppression of critical medical information. The silence after that was seismic. And then applause. Someone clapped once, unsure, and stopped. But it spread, not in celebration, but in stunned admiration. Halford banged his gavel once, then again. Order in the court. But his voice no longer held power. It echoed like a hollow drum. Evelyn stood. Slowly, she turned to face the jury, then nodded. A small, sincere gesture of gratitude. She turned back to the bench. "Thank you, Your Honor," she said softly. It landed with such quiet force that even Halford flinched. He looked down at his desk. For a long time, he said nothing. The courtroom waited. Would he offer some closing statement? A final word? A deflection? But when he finally spoke, his voice wasn't commanding. It was tired. "This court acknowledges the verdict," he muttered. "The jury is dismissed with thanks." The jurors rose and exited. Evelyn remained still. Finally, Halford looked at her. Really looked at her. "I underestimated you," he said. It wasn't an apology. It wasn't even remorse. It was an admission of defeat. Evelyn met his gaze. "No," she replied, her voice like steady rain. "You dismissed me. There's a difference." And with that, she gathered her folder and walked out. No victory speech. No dramatic exit. Just the soft click of her shoes on the marble floor as she left behind the courtroom that had once tried to humiliate her, and now bore the mark of her defiance. Outside, the media surged forward. Microphones, cameras, flashing lights, all aimed at her. She held up a hand, signaling silence, then said only one thing. Justice should never depend on volume. Just truth. And then she disappeared into the crowd. In the days that followed, the fallout was swift. Northford Pharmaceuticals stock plummeted. Class action suits flooded in. Whistleblowers emerged from within the company, emboldened by Evelyn's case. But the bigger storm, unexpected, unstoppable, was the investigation into Judge Halford. Evelyn's initial complaint had sparked a chain reaction. Attorneys who had long feared retaliation now stepped forward. Case records were reviewed. Campaign donations tracked. The Oversight Board launched a formal inquiry. Within weeks, Halford was placed on administrative leave, pending a full investigation into judicial misconduct. He never returned to the bench. And Evelyn? She never sought fame, but it found her. Law schools requested her as a guest speaker. Advocacy groups wanted her voice. Legal foundations offered her full scholarships to pursue a law degree, offers she respectfully declined. She had no interest in becoming a lawyer. She had already done what most lawyers spend a lifetime trying to achieve. She held the system accountable. Her story became legend, not for its drama, but for its discipline, not for the noise it made, but for the silence it shattered. She proved that brilliance doesn't always shout. Sometimes it stands still, waits, and then strikes with such clarity it can't be denied. In the end, the verdict didn't just convict a corporation or expose a crooked judge. It restored faith in justice, in truth, and in the quiet power of one determined soul.